Hey everyone, it's Sean Southworth, attorney for federal employee issues. Now that I've had a chance to review the actual executive order on the new DOGE initiative, I want to share my initial takes as both an employee rights advocate for federal employees, just as someone who knows this area. It's my off-the-cuff review hours after this was released, but it's my wheelhouse, so things may change. First, timelines. Within 30 days, agency heads file reports to OMB on which parts of the agency are statutory and could be cut, consolidated, and OPM initiates rulemaking to tighten suitability criteria. So no huge RIFs immediately, I would guess. RIFs are usually a complex and time-consuming process. Second, deep cuts and RIFs. This order directs agencies to prepare large-scale RIFs and eliminate offices, quote, not mandated by statute or other law. What does that even mean, right? This is going to be debated. On the surface, that might sound straightforward, but Congress, usually not the president, has the final say in creating or eliminating agencies. The White House tries to do this unilaterally or oversteps, expects serious constitutional challenges based on the separation of powers. The other thing is the White House seems to acknowledge this issue, so that's good, but expect litigation here. Third, hiring ratio and targeted exceptions. They want to say agencies can only hire one new employee for every 4 who leave, except for roles in law enforcement, public safety, and immigration. On paper, that's a policy choice, but legally, any attempt to override existing civil service statutes without proper authority could violate federal personnel laws. The Civil Service Reform Act establishes merit-based hiring as a cornerstone of the federal workforce. If this ratio hampers an agency's statutory duty to provide certain services or meet certain staff requirements, it might violate the principle that, quote, recruitment should be from qualified individuals and that, quote, selection and advancement should be determined solely on the basis of relative ability, knowledge, and skills. To me, it appears to violate 5 U.S.C. 2301b1. We'll see action here, I would bet. Fourth, civil service protections and the suitability criteria. The order calls for rulemaking to toughen suitability standards for federal employees. It does include, quote, failure to comply with generally applicable legal obligations. That to me seems a little broad. If these new standards are vague or overbroad, it could infringe on due process and collective bargaining rights guaranteed by existing law. Last, the order specifically instructs agencies to lay off, quote, temporary employees and reemployed annuitants first, and to prioritize offices the administration deems non-essential. Again, that might conflict with federal laws governing workforce reductions if they're done without following statutory RIF procedures. But the plain language of the executive order says RIFs should be, quote, consistent with applicable law. So expect action here as well. Bottom line, I think this order is legally aggressive and could face court challenges under constitutional, statutory, and regulatory grounds, particularly separation of powers and civil service protections. If you're a federal employee facing uncertainty, know there are legal checks on executive authority. This is far from settled law. Follow me for deeper dives into each of these points and practical tips on how to protect your rights. During this time, please stay informed, stay calm, and stay tuned in for more updates. And that is it for this evening. Thank you, everyone. Please feel free to check out the link tree and my TikTok to follow us across social media to stay informed. And otherwise, hope everybody has a good evening. Thank you.